In oil and gas specifically, all of our investments are passive, including these oil and gas investments. For the purposes of tax benefits, just in year one, they're classified as a general partner on their tax return rather than a limited partner. And with a general partner, that typically means, like in real estate or other sectors, that you're actively involved in the business. In oil and gas, we're allowed to do that obviously to promote energy production here. And what that allows us to do is pass tax deductions on to investors to reduce their W-2 income. But they don't have to do anything active. So reality is that they're passive. But on their tax return, it says that they're a general partner just for tax purposes, just for year one. So is that okay as long as, hey, they can prove that they didn't actually have any involvement in drilling or finding the deal or managing it?
Yeah, I would still categorize that largely as a passive investment. Now, again, there's no case law on this, but the reason probably there's no case law is it's hard to imagine an officer really taking issue with that.
Okay.
What they would potentially take issue is they see on paper it looks like maybe you're working. I've seen that come up before where I've had clients that there was some kind of documentation that looked that maybe they had started up this business and were running it prior to getting work authorization through a visa. So not exactly the same because in your case, they're never interested in working in oil and gas probably. But at the end of the day, we're talking about both parties are on H-1B or what have you. They do not have work authorization for that particular business. And when that's come up, depending on the facts, I would present evidence that no, yes, they're listed as the CEO and they are the CEO, but they're not performing any work and they're waiting until it's approved. And here's the evidence of that. And thus far, I've never had a case denied on that issue. Obviously, we have seen cases of people engaging in unauthorized employment. And to be clear, that's really what we're mainly talking about. When we're saying a violation of status, it would presumably be based on unauthorized employment, which would be a violation of your non-immigrant status. So if you were in the concept of employment is viewed very broadly. So if you are doing something for your own business, not getting paid, but you're doing it for your own business, that still could be viewed as unauthorized employment. If you were running things, if you were managing things, if you were involved in that. But, again, paid or unpaid. But again, if all it is on paper, you are a partner. Now, how many partners are there? I'm assuming it's a bunch.
It's a bunch. Yeah, every investor gets classified as a partner. So previously, our capital raises were around 10 million or so. And so we may have, call it 100 investors at most. We're launching a $100 million fund now. So there'll be a lot, call it maybe even up to 1,000 investors.
Okay. Yeah, I mean, again, all of that, and you would probably get whoever it is that's actually running the company. In a perfect world, I would say, hey, can we get an affidavit from them explaining that maybe we get a letter from a tax lawyer explaining the tax benefit and no, you don't actually have to be involved in the business. Maybe I show them the list of the partners, and you can see there's 100 partners on here. We're not
Yeah.
all involved running the show. We're just listed here for tax benefits. So I think the risk is incredibly low. I cannot imagine a scenario where an officer would even really push back on this. And if they did,
We do.
there's ample
Yeah.
evidence to show that you're not involved. So if I were not going to do this, I don't think it would be for this reason that I'm going to be violating status. You're just passively investing the cash.